welcome to Tarun IAS. Today we will be discussing editorials from 4th of October 2022. So let's start with first topic of the day. Recently, Parliament Standing Committee has presented its report regarding the mediation bill, which was presented in the Rajya Sabha in the year 2021. Now we will talk about what are the different provisions of the bill and what are the concerns regarding this bill. So the first thing is that you can relate this topic with General Studies paper 2. You can relate this topic with General Studies paper 2 from the mechanism, laws, institutions and bodies constituted for the betterment and protection of vulnerable section. You can also relate this topic with the alternate dispute redressal mechanism, right? So we will be talking about what are the different alternate dispute redressal mechanisms, but we will specifically deal with the mediation, right? So alternate dispute redressal mechanism and the mechanism, laws, institutions and bodies which are constituted for the betterment and protection of vulnerable section, right? So let's move on. What is mediation? But before mediation, let me talk about what is ADR, that is alternate dispute redressal mechanism. Now in your syllabus, ADR has been specifically mentioned and there are various ways for alternate dispute. Alternate dispute redressal means something which is outside the traditional court system. That means Supreme Court, High Court, the subordinate courts. So ADR out of the purview of these traditional system, or you can say the normal mechanism of availing justice. ADR includes your lok adalats. Let me delete this. Now ADR, it includes lok adalat, your tribunals which are constituted either for a specific purpose or they are constituted for the general purpose. So tribunals, but majorly they are constituted for a specific purpose. So tribunal, lok adalat, your mediation that we will be dealing with within this bill, and conciliation, arbitration. So these are different forms of ADR, alternate dispute redressal mechanism. We are specifically dealing with the mediation because of the mediation bill in the news recently. Now what is mediation? Mediation is basically a voluntary mechanism between two parties conducted by a third party in order to arrive to a conclusion, in order to resolve the dispute between the two parties. Now what is the objective of this mediation bill? The definition which I have taken here of mediation is from the Mediation and Conciliation Project Committee of Supreme Court of India. So you can directly quote this committee and use the definition in your exam if question regarding this bill has been asked, or if it is asked, then you can use this definition. Now what is the purpose of this bill? The purpose of the bill is basically to promote the mediation in India so as to arrive to a conclusion or resolve the dispute which enhances harmony in the nation. We will also talk about what are the benefits of this mediation bill, but the bill basically aims to promote and encourage and facilitate mediation, especially the institutional mediation, right? So basically the bill aimed at institutionalizing mediation as a mechanism to resolve dispute, whether it is commercial or otherwise. That means the resolution of the disputes of commercial in nature. This becomes important because of India's engagement with various commercial companies and losing cases. For example, the two most important cases that India lost when it comes to international arbitration was the Vodafone case. The Vodafone case in retro taxation. The second case was the Karen Energy case. Therefore, mediation or arbitration in India becomes highly important. So harmony in nation and the India's specific need to promote ADR and the cases of commercial nature and non-commercial nature. For example, involving dispute between between two citizens, involving dispute between two citizens. So the bill aimed to promote all these things. Now let's see who can mediate, right? So it is any third party. Basically, a mediator is a third party who is either appointed by the parties themselves, like, because the mediation, it works on trust. It works on mutual trust, right? So therefore, the parties themselves can appoint a third party as a mediator whom they trust, or because the mediation bill aim to institutionalize the mediation mechanism, therefore there will be mediation service provider. That means the people of eligibility can establish a mediation firm to provide services of mediation, right? So these are the two provisions which were given in the bill. Now let's move on. Now, why India needs mediation? Because of the high pendencies of court. If you see the data of national judicial grid, 4.7 crore. The first point, 4.7 crores of cases are pending. Out of these 4.78 crores, approximately 87% of the cases are pending. Approximately 87% of the cases are pending in subordinate courts. Right? Approximately 12% of the cases are pending in high courts. So if you look at the pendency of the cases, resolving dispute at the mediation or at the pre-litigation stage becomes important for India. It is basically a fast track method, right? And what is also important here in this mediation is that the parties themselves are involved, right? Parties themselves are involved in resolving dispute. In resolving dispute. Now, they will not feel that they have been imposed upon any order, right? The resolution of the dispute will be on terms and condition of the parties themselves. So they will feel more satisfied with the outcome, right? So this is also the reason it is a fast track method, and it will resolve the dispute at the community level itself, right? If mediation in India is promoted, then the petty issues that arises in India because of the social disharmony, or because of the social disengagement, or because of any other reasons, then the dispute will be resolved at the community level itself. There is no need to go to the high court or to the subordinate court, district courts and all. So therefore, the pendency of the court will be reduced, and effectively it will also leads to fast track of justice. Right? So fulfilling the fundamental rights under Article 21, right? It will promote social harmony. And time productivity, reducing the pendency of the court. Also, it will be cost effective. If the issues are, or if the disputes are resolved at the community level itself, the money which goes into the fees of lawyer, etc., and other paperwork, it will also get reduced. So it is money and time productive. It promotes social harmony. It will resolve the dispute at the community level itself. It will fast track the method of resolving dispute. It will also uphold the fundamental rights of the citizen, and it will also reduce the pendency of the court. So these are the points that you can keep in your mind if the question is asked about the mediation bill. Now let's see what are the current mechanism. Currently there is no institutionalized mechanism of mediation. However, there is no institutionalized mechanism. That means standalone statute is not there when it comes to mediation. However, the provision of mediation is given in Civil Procedure Act of 1908, Arbitration and Conciliation Act of 1996, the Companies Act of 2013, the Commercial Court Act of 2015, and the Consumer Protection Act of 2019. Provisions are given in all these acts with respect to the mediation, but there is no standalone statute or there is no institutionalized mechanism when it comes to mediation. Also keep in mind that India is signatory to the Singapore Convention. But there is one important point that you need to keep in mind, that India signed Singapore Convention in the year or became its member in the year 2019, which is officially known as United Nations Convention on the International Settlement Agreement, right? However, India has not ratified it, right? The parliamentary approval is yet to be given. Right, let's move on. Now let's discuss different provisions of the bill. First, the bill aims at institutionalizing the mediation, which I have already told you how, and also it aims to establish a mediation council of India, which will be overlooking the regulation and other provisions of the bill and other different mechanism with respect to the mediation. So provision is there for the establishment of the Mediation Council of India. It also provides for the mandatory pre-litigation mechanism, mediation and pre-litigation stage. That means before the case goes to the court, there is mandatory mediation. The mediation has to be there, right? It also seeks to safeguard the right of the litigants to approach competent adjudicatory forum courts for relief. The mediation process, it will be confidential, and there is a penal provision for breach of confidentiality. Immunity will be provided against its disclosure. Right? The terms and condition of the mediation and other provision when it comes to mediation, they will be confidential. The mediation agreement will be legally enforced because it seeks to institutionalize the mechanism. So legal enforcement needs to be given to the mediation process. Otherwise, the parties will not arrive at any conclusion. They will always, what will happen if the legal enforcement of mediation is not there? The party to the dispute, they will use it as now this is also another concern that we will discuss. Otherwise, the parties, they will use it as to delay the process, right? So therefore legal enforceability has to be there, so that and it can be registered with the district state within 90 days, right? Within 90 days. It also promotes the community mediation, which we already discussed. Right. The other provisions of the bill are, it also provides for the list of certain matters which will not be covered under mediation. For example, the cases which involve criminal prosecution, they are not to be mediated. For example, the cases under the POCSO Act. For example, the cases of rape, dowry. If there is, if there is injury or etc. So there are certain cases such as these which will not be covered under the mediation process. The parties, they may appoint third party as mediator or avail the service of the mediation service provider, right? This also we discussed that it is up to the The parties do have this freedom that they can appoint the person whom they trust, or whom the third party who can ensure the parties to the dispute for a consensus building and for a complete resolution of the dispute. The bill also applies to the international. Now this point is important, that it also applies to the international mediation only needs to be only if they are conducted in India, right? That means the India wants the international mediation to occur in India, then only it will apply to the international mediation. However, this has become a concern. This point of the bill has become a concern. So let's see the concern which arises due to the bill. First is the compulsory nature of the pre-litigation mediation, right? The compulsory nature of the pre-litigation mediation. What will happen? Delay in justice, and also it will become a tool in the hands of the litigation to delay the case disposal, right? So compulsory nature is one of the concerns associated with the bill. The denial of justice under Article 1. Parties will ensure cost if fail to attend mediation without reasonable reasons. Now I'll tell you what this point means. That the bill says if two parties, for example, there is party 1 and party 2, if there is a mediation process between these two parties, and if they fail to arrive at any conclusion, or if they fail to resolve their dispute, then they will incur cost, right? They will incur cost. Now this provision of the bill is becoming problematic, right? If they are not able to give any sound reason, that why they have failed to arrive at a conclusion after the process of mediation, then they will incur cost. This is the second concern with the bill. The clause 6 of the bill, which is another concern, is that pre-litigation mediation will also be implemented in matters which are pending before the tribunal. However, the committee says that it is not understanding that how a matter which is pending before the tribunal can be considered as a pre-litigation at a pre-litigation stage. So this is another concern, right? The bill also considers international mediation to be domestic. Now the committee observed that this is somehow, it is contradictory with the provisions of the Singapore Convention and what are the provisions which are given in the bill. However, the government said that because the Singapore Convention has not been ratified by the Indian Parliament, right? So this is another concern, that we have though signed the convention, we have still not ratified it. So therefore, it becomes a little contradictory that how the international adjudication will take place in India, how the provisions of the bill will be enforced when it comes to international arbitration and settlement of the cases. And also there is a concern arises that if India does not align its provision with the Singapore Convention, even after signing it, then it will be excluding itself from the tremendous benefit that it will get by the worldwide enforceability, right? So let's see what the... So these were the concerns of the bill. Now let's see what are the recommendations of the committee. Now the committee included the government in the cases of non-commercial nature under mediation. So far the government of India has been dragged into commercial cases, for example, like the white industry case, the Vodafone case, and the Karen Energy case. Right, the Karen Energy case. India had to refund approximately, $7,500,000. I think, if I'm not wrong here. So the committee recommended government to be included in the cases of non-commercial nature. It also recommended that the definition of the international mediation and the provision of the Singapore Convention are not included. Right. So the committee recommended the Parliament to resolve this concern. However, the government said that India is yet to ratify the Singapore Convention, right? So we will see, if there is another editorial comes when when India signs, when India ratifies this convention, we will discuss this mediation bill. Otherwise, so far, this is what has been presented. This is what came in the newspaper. So committee recommended for rearranging certain clauses, for example, the clause 6, which we discussed, right? And it also suggested the government to reconsider the compulsory nature of the pre-litigation mediation. This is another recommendation of the committee. It also recommended that the mediation process to be completed within 90 days with the extension of 60 days rather than the 180 days, right? So instead of having 180 days, it recommended that it should be 90 days with the extension of 60 days. So this was all about the mediation bill. Now, let us move on to another important topic that was in the news because of the major progress in the international relation. Major progress in the international relation is that India pitched for its permanent membership in the United Nations Security Council. This has come, and India has been long. India has been vocal, and it has been trying for a very long time to avail the permanent membership of the United Nations Security Council. Two of the major world countries, USA and Russia, have also given statement at the 77th United Nations General Assembly regarding the expansion. They also hinted, the United States President Joe Biden and the Russian diplomat, they also hinted the expansion of the United Nations Security Council. Veto power was not, of course, mentioned. Let's see how India deals with it and what are the importance of being a permanent member of United Nations Security Council, why India should become a permanent member of United Nations Security Council. Second part that we'll be dealing with. And the third part that we will be dealing with is the reform in the United Nations Security Council. What are the reforms that are needed in the United Nations Security Council, UNSC, and why these reforms are needed, right? And why these reforms are needed. India is an emerging nation. It's a fifth largest global economy, and it is also playing a very crucial role in the Indo-Pacific region, especially in the Indian Ocean. Considering that how India emerged post COVID-19 crisis, where the major countries even failed to control the cases of COVID-19, India did emerge as a shining example. Not only it controlled the domestic cases, but India also exported vaccines to the least developed countries. India is also hub of the generic medicine. So therefore, India, which is playing a major role when it comes to international, when it comes to being vocal about the international relation, international issues, whether it was Afghanistan, whether it was Russia-Ukraine war, right? Where recently Prime Minister talked about the ethicality of the war, that how India is also a responsible nuclear power with its no first use doctrine, that how India is also emerging as a regional player, especially the post 2000 tsunami disaster, especially post 2000, India is also emerging as a regional player, and humanitarian intervention. Therefore, India is the deserving candidate for the permanent membership of the United Nations Security Council, right? You can relate this article with General Studies Paper 2, the bilateral, regional and global groupings and agreement involving India or affecting India's interest. You can also relate this topic with the important international institutions, agencies and fora, their structure and mandate. We will be discussing UNSC here, right? Now let's see United Nations Security Council. It was established in the year 1945 with the mandate to promote international peace, and collective security, right? These were the two important mandate under the remember this, under the chapter 7 of United Nations Charter. Chapter 7 of United Nations Charter, right? So it was established in the year 1945 as one of the 5 principal organs of the United Nations. Its mandate was to establish peacekeeping operation, which is taken care of by the Peacekeeping Operation Department, United Nations Peacekeeping Operation Department, UNAPOD, and international sanctions, embargo, the military action under Article 42 of the United Nations Charter of Chapter 7 through the passage of United Nations Security Council resolution. So there are 3 important articles that we will also talk about, but you don't have to go into the detail of this. Remember this, that it is the only United Nations bodies which can issue the binding resolution on its member, right? It is headquartered in New York, USA. Let's see the function and power of United Nations Security Council to promote peace and security, to ensure, provide the United Nations peacekeeping operation. You can say it is basically based on the humanitarian intervention. Humanitarian intervention. Now, one topic that you need to prepare here for your General Studies paper 4 is that how the military intervention promote peace, right? How military intervention can be counted as the humanitarian intervention. So you prepared this topic for your General Studies paper 4, that is ethicality of the war. So this you need to prepare. Another power or function of the United Nations Security Council is to impose sanctions, international sanctions, the diplomatic relations, severance means cutting off ties, the financial restrictions, penalties, blockade, and even the collective military action, right? Members, let's talk about the members of United Nations Security Council. There are total 15 members of United Nations Security Council, which was expanded in the year 1968 from 5+6 to 5+10. Right? Now what is this 5? This is called as the permanent 5. These 5 countries, including US, UK, Russia, China, and one more, that is what? France. Right. So these 5 countries, they are the permanent 5 countries, and they have this veto power. That means their vote against any resolution means dissolving that resolution, or that resolution will not be passed if any of the 5 members, the permanent 5 members, passes a veto vote, right? So this was about the members. We will also talk about that how these non-permanent members they get selected, what is the 2/3 majority, and the special majority, which is becoming a major hurdle when it comes to the permanent membership of India in United Nations Security Council. So let's look at this map. So there are 2 members. There are there is one member is from the Eastern Europe. There are two members from the Western Europe, right? There are two members from this Asia region, three members from this African grouping, and two members from the Latin America, Latin and Caribbean countries. All right. So this is how region-wise, there are total 5 regions from where the 10 members are selected for a 2-year term, and 5 of the members are replaced every year. 5 of the members are replaced every year, and 10 members are selected, and each member has a 2-year term. India's term was started from the year 2020 to 2022. That means India's term is going to end, right? It is going to end. Let's move on. Right. So these permanent 5, they have this great power unanimity, which is commonly known as the veto power. India was elected as the United Nations non-permanent member in the year 2020, which is the 8th time India has been elected for this seat, and it is also committed to promoting a responsible, right, and inclusive solution to the international peace and security. India also calls for the equitable representation. You can say this is what the India's agenda is for its membership to the for its permanent membership to the United Nations Security Council, for equitable representation and multilateralism. India is also committed to reform the multilateral institution, not just the United Nations Security Council, but WTO, WHO, and India also seeks to become voice of developing and least developed countries. India has a 5S approach when it comes to reforming the multilateral institution, which is Samman, Samvad, Sahyog, Shanti and Samriddhi. So you can mention this in your exam if the question is asked about India's claim for United Nations Security Council. Now let's see what are India's claim for United Nations Security Council. India believes in multipolarity, right? There should not be hegemony for any one country. For example, US had hegemony for a very long time. Then the rise of China started, right? Post-Cold War. This is what we are talking about, the post-Cold War. We will also talk about that how this notion of collective security started, and how this United Nations Security Council's collective security is also challenged by the collective security of Warsaw Pact or the NATO. We'll see that, right? So this is post-Cold War, that India believes in the multipolarity. It also believes in rebalancing. There should not be a unipolar or a bipolar world, right? Currently we see that India's self-enlightened interest is opposed by US-China trade war. The unilateral sanctions of USA on various countries also affects India's interest. For example, sanctions on Iran. This has majorly affected India's stake in West Asia, right? And also is India's stake in Afghanistan. So how this happened? You see the Chabahar port, and also the oil field which was given to India's oil company was also withdrawn. So therefore these sanctions on Iran has caused a major loss to India's power in West Asia. So therefore India seeks to rebalance the multilateral fora. It also believes in the multipolarity, the fair globalization, globalization. If you see the WTO terms and the recent WTO Ministerial Council meeting, that how it has in fact always favored the developed countries, right? So India seeks to have fair globalization and reformed multilateralism, right? Reformed multilateralism. Now here one more topic that you need to consider is that how India's foreign relation policy has changed over the years. Foreign relations policy has changed over the years from moral idealism to moral realism to multilateralism, and now India wants to have what is known as the self-enlightened interest, right? India wants to have its own interest, but not at the cost of other countries. Like unlike the major powers of the world, India's self-interest is not just a self-interest at the cost of other countries, but it is self-enlightened interest, right? That means India wants to take other developing and least developed countries together to the prosperity and sustainable development goals, right? So this is how you can relate different issues and different topics that are given in your syllabus, right? India is also the fastest growing economy. If you look at the trajectory of India, especially post COVID-19, that how it has regained itself. In fact, the economic survey also says that India has shown the V-shaped recovery. However, the touch sensitive industries such as hospitality, tourism, etc., they were of course skewedly affected, but India still showed a V-shaped recovery. So if you look at the economy of India, it is fastest growing economy in the world. So I'm talking about in with respect to the claims at UNSC, right? So recently it has also acquired the nuclear weapon state, and India is also enhancing its military capabilities. India is also reforming its military, indigenizing its weapon and ammunitions, and it is emerging as not only a nuclear weapon state but also a responsible nuclear weapon state with its no first use doctrine, right? India would surpass China in the year 2023 as the largest populous country in the world. I mean, in terms of the demography. Don't mention in your exam, in your answer, as the largest population or highly populous country. Use the word demography. Like in terms of the democracy, it will surpass the China, because if you use this word demography, it will reflect the potential of India. Right, not population as a burden, but it will reflect population as a source of skill, productivity, etc., right? Because if you look at the European countries and if you look at Japan, the population is declining. The population, the dependency ratio is high, and there is a need for geriatric care, right? So therefore, India, which is a major service provider hub, can also, therefore its demography is in alignment with the need of the world, right? So India is going to emerge in the future. This is how you should write in your exam, right? So it will surpass China, and it is also committed to the establishment of the rule-based multilateral international regime. Here you can give example. Of UN clause, which is United Nations Convention on Laws of Seas, that how India is committed to the rule-based order. All right. India is also the fifth largest, as it was stated by our finance minister. India is also the 5th largest in terms of its economy, and it is the largest contributor to the peacekeeping mission, right? It is largest contributor to the peacekeeping mission. We will now, let's talk about this peacekeeping in detail, and then we will talk about the different roadblocks in India's permanent membership. All right. So let's see the peacekeeping. And then we will see the reforms in United Nations Security Council. Peacekeeping started from the year 1948, right? Collective security. How it happened? Before World War I, let's see the timeline. This is World War I. Before World War I, every country was responsible for their own security, right? So there was a notion of self-security. That is the reason why World War I happened. There was a lot of mistrust and etc. etc. You can read this in your world history. Right? So self-security was the notion. Then happened the World War I, and then was established what is known as the United League. Right? League was established. Oops, I think spelling is. So League was established. This proved to be a very ineffective organization, right? Therefore, World War II. After the end of World War II was established United Nation. United Nation with commitment to international peace, security, collective military action if there is any threat to the international peace, right? Collective military action. Collective military action, right, as a solution to the international dispute, etc. etc. Now let's see. So there are certain points that you need to keep in mind. First is the chapter 7. Chapter 7, which talks about the collective security. There are 3 articles which specifically deals. If you remember this, fine. If you don't remember this, doesn't matter. Article 40, Article 41, and Article 42. Article 40 talks about the peacekeeping operation. Article 41 talks about this collective force and sanctions, embargo, etc. Article 42 talks about the military intervention. Military intervention. Right. So this is how it deals with. Right. Now let's see what are the different roadblocks in the permanent membership of India. First, it is the objection by certain members, for example, China. It is also seen as proliferating nuclear power. However, you can counter this point with that India is not just a nuclear state, but it is a responsible nuclear power, and you can mention its no first use doctrine. You can also mention that how India's foreign policy is committed to the self-enlightenment interest, or enlightened self-interest rather. The correct phrase should be enlightened self-interest. Enlightened self-interest. Okay. Hurdle due to the G4 grouping. Now let's talk about the different groupings who are aiming for this permanent membership. The first is the G4. The first is the G4 grouping, which consists of the Brazil, India, Japan, and Germany. Now, why India is facing hurdle because of this G4? Although G4 is committed to the permanent membership. However, all these countries are demanding the permanent membership. Brazil's candidature is opposed by Argentina. India's candidature is of course opposed by China and Pakistan. Japan's candidature is opposed because Japan was once an imperial country. imperialistic, country. Germany's candidature is opposed because Germany is a European power. European power. Already there are this UK and France as this permanent member. So we cannot have another European power as permanent member. Therefore, this is how the G4 grouping is becoming a hurdle. Then there is another group called Coffee Group. This is led by this Italy and all. So this group is also opposing permanent membership of. It also has Pakistan, So they are also opposing India's candidature for permanent membership. There is another group called L69. Right. India is also a member of L69, and it does promote. It does support the India's candidature for permanent member. It consists of all the developing and least developed countries. It also has the African grouping. Africa group is also there. A separate African group is there. Which says that majority of the peacekeeping operations, majority of the military interventions are in Africa and West Asia. Therefore, there is a disproportionate representation which is not in favor of Africa and West Asia in United Nations Security Council. So, Africa group does demand that its number of members should be increased from 3 to whatever that they are demanding. However, the problem with Africa group is that there is no consensus between them, and they have not even able to select the candidate for the permanent membership, right? Whether it will be on the basis of the rotation or whether it will be the same candidate will be there. These are the caveats that they need to solve, right? So there is another thing which is the OCI, this organization, this OIC is also saying that there should be one member from West Asia or from the Islamic countries, right? Or from the Islamic countries. However, the problem with this is that there is no membership on the basis of the religion, right? There is a membership on the basis of the region, but not on the religion. So therefore, the OIC's proposal was rejected in the first instance itself. Right. We can definitely have a member from the West Asia, we can increase the member from Africa, we can have member from Latin and Caribbean countries, right? And Africa and West Asia needs to have more member because majority of the military action they are conducted here in this region. And also one more hurdle in India's permanent membership is the 1998 decision for the resolution to be necessarily passed by the securing special majority. Now, what is the special majority? There should be 129 votes, like in total. In total, there should be 129 votes and there should be no veto votes. Like, is it really possible? Right, no veto vote. No veto should be there, right? For any resolution to be passed and for any reform to have in the United Nations Security Council, there's a resolution necessarily has to secure special majority. There are there are proposals that this needs to be changed. This needs to be changed either to the majority or to the consensus. Right? So these are the different proposals, and these are the different hurdles that comes in the way of India's permanent candidature in United Nations Security Council. Now, what are the different reforms that needs to that United Nations Security Council needs? First is the categories of membership. If you look at the membership, now let me go back to. If you look at the membership, Eastern Europe has only one member. If you look at the membership, Eastern Europe has only one member. Africa, which is such a large continent, it has only 3 members. West Asia has no membership at all. Right? Latin and Caribbean countries, they have only 2 members. Right? So Asia has only 2 members. Eastern Europe has two membership, in which France and UK are permanent member. So there is disproportionality when it comes to representation, or you can say there is inequitable representation. There is also one more thing that you need to see, that all the members they were party to World War II, and this World War First, which caused such a huge disruption to the peace in the world and caused mistrust in the world, and also the environmental damage was another thing. These factors have not been considered when the United Nations was established, and when United Nations Security Council granted permanent candidature to these countries, right? So categories of membership it needs to be reformed. The question of the veto. There was a proposal that UN Security Council. There was a proposal that UNSC, it needs to be expanded, can be expanded, yes, but the new members will not have veto for 15 years, will not have veto for 15 years. This was the proposal. However, it does not make any sense to be a permanent member or not have a veto, and not have a veto. Either you abolish the veto power completely, or you give permanent membership along with the veto, right? The regional representation needs to be changed, which we saw in the map already. The size of an enlarged council and its working methods. You see the last when Security Council was expanded was in the year 1968. Now the United Nations membership has increased from the 51 when it was formed. 51 when it was formed in the year 1945, and now the United Nations membership is 193 members, right? Still there are only 15 members in United Nations Security Council, right? The Council and the General Assemblies, everything has to be reformed. The working methods, like we spoke of this necessary special majority, all right? Now, let's see why reforms are needed. Now, changing geopolitical situation. This is not a wartime scenario now. Every country is emerging, especially the developing countries are also emerging. You look at the status of Bangladesh, from least developed countries to it has become developing country. It has acquired the status of developing country from the least developed countries since its liberation in the year 1971, right? So geopolitical situation is changing. India is also playing. Now this is specifically, we are talking about the UNSC reforms, not about the India's candidature as a permanent member. Like why the reforms are needed in United Nations Security Council. India is also playing as a regional player, as well as a player in the international fora. It has its own voice. It has a major contribution in peacekeeping operations. See Afghanistan. India provides the food aid, and of course India is committed to no military action in Afghanistan. However, the humanitarian intervention of India is always there, right? The International Solar Alliance, right? Its responsible commitment to mitigating and alleviating the effects of climate change. International Solar Alliance, CDRI. The supply chain resilience network. The crisis of legitimacy and credibility. The crisis of legitimacy and credibility. Inequitable economic geographical representation. This is why the reforms are needed. Now, what is this crisis of legitimacy and credibility? Now, if you look at the working of United Nations since its inception, United Nation, it has not been able to prevent regional disputes. It has still it has still not been able to resolve disputes in West Asia. It is considered as you can say as a puppet under the major powers. For example, US, the United States of America, unilaterally imposes sanction on any country. That works against its interest. It sees its interest first. It also passes regulations like CAATSA, right? Which affects India's interest. Right? So UN has not been able to do anything with respect to these. So there is a crisis of legitimacy and credibility when it comes to the United Nations. So therefore reforms are needed to check all these hegemonic power, to check the hegemonic nature of the major power. You look at China, right? Its tactics in Indo-Pacific, the recent border clashes with India, for example, the Doklam dispute in 2017, and recently in 2020 we saw this Galwan Valley clashes. So United Nations has not been able to resolve such disputes, especially the border disputes. It has not effectively played any role when it comes to the Russia and Ukraine war, right? Since 2014, when Russia annexed Crimea Peninsula of Ukraine, the United Nations has not worked effectively to resolve these regional disputes. So therefore, there is a crisis of legitimacy and credibility which needs to be resolved via the process of reforms, right? The North-South divide that exists. Now there is no geographical North-South divide, but if you look at the climate change, the effect of climate change on least developed countries, the island nations and developing countries is more. However, the responsibility of climate change is not taken by the industrially advanced nation. All the developed countries, they have developed their industries, but there is no climate change responsibility, and they have not been able to uphold the common but differential responsibility, CBDR, right? So North-South divide does exist. This North-South divide does exist. The climate change, the per capita carbon emission. So the inequality that exists. Look at the condition in Africa, right? Post-decolonization, there have been many disputes which has arose because of the pre-decolonization era. They have continued basically. So look at the condition of Africa, right? So North-South divide does exist, and that's why there is a reform which is needed in United Nations and Security Council. The emerging issues that how irresponsibly the major military powers are acting. The emerging issues concerning the health, for example, the zoonotic diseases, right? And how WHO was ineffective in dealing with COVID-19, right? So therefore, there is a crisis of legitimacy. There exists North-South divide. There are emerging issues which needs to be tackled, and therefore reforms are needed. Right? Now, who are all supporting India's candidature? We discussed that there is G4 grouping. There are unilateral support from countries also. It's not that the countries are not supporting. For example, Russia has been vocal when it comes to supporting it. However, there are of course geopolitics that plays along, and France has also been supportive of the United Nations reforms and the permanent candidature of India in United Nations Security Council. So with this, we are done for today. Thank you.